Good morning, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to Smart Loc TV. If you're new to the channel, do me a favor, go ahead and hit that subscribe button, turn that notification bell on, and hit that like button. If you're not new, just hit the like button. I'll give y'all a few seconds to do that. All right, so I'm gonna jump right into this. Y'all know I've been gone for a while, probably almost 6 months. I haven't posted a video. I do want to talk about something. I posted this on my YouTube channel maybe a year or a little over a year ago. It is in here. It's going to be in this section. If you're new to my channel, I always post case law down here for you to read and go over. So what I would advise you to do is just go down. Just keep going down. If you're curious about what's been posted on my the comment section of my channel, just keep going down like this. And you're going to see case after case after case after case after case after case of a whole bunch of just different various topics in law. But I want to talk to y'all about something. And this is basically, it's going to be constitutional courts versus legislative courts. And the case law that I'm going to be using is right here. I cited this on my YouTube channel a while back, like I said, probably about a year, maybe a little over a year ago. And I'm going to read it to you, and then I'm going to explain it to you. I've used some software that would help me explain this to y'all in a way that y'all can understand it. I already know what it means. I knew what it meant not too long after I read it a little over a year ago, and my mouth just hit the floor, but it makes so much sense. So without any more dialoguing on unnecessary stuff, I'm gonna go ahead and jump right into this. So this is the case State ex rel. Winter versus Sayer. This is an Alabama Supreme Court case. Just to let y'all know, I don't care that this is an Alabama Supreme Court case. Okay, this is a principle. All right, this principle applies everywhere, all over the country. All right, so y'all need to understand that. I don't care what this case was about. I haven't even read the case. I don't even care what it's about. I care what this says right here, because this is one of the principles that was established in the case. This is what I care about. All right. It says, the system is in itself and of itself complete. And though, in other words, although there has been a grant or reservation to the General Assembly, aka the legislature, of power to establish inferior courts of law and equity, meaning administrative so-called courts, statutory courts, aka territorial courts of law and equity, of colorable law and equity, because it's not law and it's not equity because there are no statutes in common law or equity, generally speaking. All right. But anyway, although there has been a grant or reservation to the General Assembly of power to establish inferior courts of law and equity, there has not been any part or any fraction or fragment of judicial power left in abeyance, awaiting the happening of any future event or the exercise of future legislative power to vitalize or quicken into activity. If the General Assembly never exercised the power to establish inferior courts with which it was clothed, and its exercise is purely a matter of legislative discretion, the whole element of sovereignty known as judicial power would still exist, confined to tribunals, which may properly be said of constitutional creation. So what this is saying, without saying it, You have to make reasonable conclusions based on what the case says and what it doesn't say. You have to make reasonable conclusions. So what they're saying is, I'm going to put it to y'all just plain and simple, just like this. If the legislature never created statutes, or if the legislature never created courts, there would still be law and there would still be a court system in Alabama. That is what this means. Because you are under God's law, which is common law and equity. That's why the sovereign people of Alabama created a court for themselves. These are called superior courts, aka courts of general jurisdiction. Notice the term superior is the people's courts and inferior is the legislative court. I want y'all to pay attention to that. So we're gonna go down. I'm gonna go down though. We're going to decipher what all of this means. This holding, we're going to decipher it, and I'm going to explain it to you what it means. This applies everywhere. So what you should do, if you're watching this video, go and read your state constitution and go to the judicial article within that state constitution, and in that you will see which court for that particular state was created by the Constitution, whether it be called a district court, circuit court, or whatever, or it's going to be called they're going to use terms like superior court, court of general jurisdiction, circuit court, or district court. They're going to use terms like that. Those are the types of terms they're going to use. They may use something a little different than that, but generally speaking, those are the types of terms that they're going to use. All right. So the passage from State ex rel. Winter versus Sayer, blah, 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 articulates several key principles about Alabama's judicial power. Let's dissect the language and its implications. Completeness of the judicial system. Text. The system is in itself and of itself complete, meaning the Alabama Constitution establishes a fully functional judicial system by vesting the entirety of the state's judicial power in designated courts, Supreme Courts, circuit courts. These are courts of general jurisdiction, aka superior courts. These courts do not, I repeat, do not need a statute from the legislature to do anything. They have their authority from the sovereign people of Alabama. That's where they get their authority from. And it's only the sovereign people of Alabama who can abolish these courts. The legislature has zero control over these courts because they did not create them. All right. This system is self-contained and operational without requiring further action from the legislature. That's what they're saying. The Constitution allocates all judicial power to these tribunals, ensuring that the judiciary can exercise its authority immediately upon the Constitution's adoption. Forthwith. Implication. The judicial branch is called a co-equal branch of government, with its authority derived directly from the Constitution, not dependent on legislative permission or additional statutes. This reinforces the judiciary's independence and its ability to operate under common law and equity jurisdiction. I don't know what this is. Let me get this out of here. Sometimes stuff be messing up, but you get what I'm saying. This is everything that I'm reading you is 100% accurate. It's all accurate. Now here we are. Legislative power to establish inferior courts. These are territorial courts, administrative courts with zero judicial authority. They don't have any judicial authority whatsoever, none. Text. Although there has been a grant or reservation to the General Assembly of power to establish inferior courts of law and equity, meaning the Constitution grants the legislature discretionary authority to create inferior courts, aka city courts, district courts, to handle specific judicial functions. But I want y'all to pay attention to this now. The legislature does not have any judicial authority to give any of the so-called judges in their inferior courts. They don't have any because we have separation of powers. That's how I know that a city and a county is an administrative agency, because administrative agencies are a part of the executive branch of government, and they exercise so-called all three powers of government, but they don't call them judicial power, or they don't call it legislative power. They call it quasi-judicial power and quasi-legislative power, meaning even though it's not judicial and legislative, we're going to treat it like it is. You're in a territory. This power is permissive, not mandatory, meaning the legislature can choose whether to establish such courts without affecting the judiciary's overall authority. Implication: the legislature's role is limited by organizing additional courts, not defining or activating the judicial power itself. The courts created by the legislature operate within the constitutional framework subordinate to the constitutional courts, because they're inferior courts, because the legislature is not sovereign. Hope this is making sense to y'all. So again, I'm going to say this again. If the legislature never created any courts, or if the legislature never created any statutes saying you can't speed down the highway, or you can't murder somebody, or you can't drink and drive, but you murder somebody, all right? Or you speed down the highway and you hit somebody, or you drink and drive and you hit somebody. Doesn't matter if they have the statutes for that or not, because you can still be prosecuted for it, because you are under God's law, common law, and equity. And that is the jurisdiction that is going to determine your fate by courts that were created by the Constitution. If there was no law, if there was no courts created by the legislature, there would still be law and there would still be courts created by the sovereign people within Alabama. And this principle applies everywhere. So y'all need to get this through y'all heads. All over the country. No judicial power left in abeyance. Text: there has not been any part or any fraction or any fragment of judicial power left in abeyance, awaiting the happening of any future event or the exercise of future legislative power to vitalize or quicken the activity. Meaning, all judicial power is fully allocated by the Constitution to the designated courts at the moment of the Constitution's adoption. No portion of this power is dormant or contingent on future legislative action. The judiciary does not need the legislature to activate its authority. It is inherently active and complete because the legislature is not sovereign. They are public servants. They are your power of attorneys. And you gave them a chart of authority. You gave them a charter. And that charter is called the Constitution for the State of Alabama, or Constitution of Alabama, or whatever you want to call it. They're not sovereign. They can't do whatever the hell they want to do. This applies everywhere. Implication: this ensures that the judicial system can function even if the legislature never creates additional courts. It protects against legislative overreach, preserving the judiciary's autonomy and its ability to adjudicate disputes, including those under common law and equity, as relevant to your trust. So they're talking about a trust right here, something like that. This is equity jurisdiction, by the way. Y'all getting this? You go and read your state constitution. And I know how to invoke common law jurisdiction in a court. of general jurisdiction that was created by the Constitution. It is so easy. All of it is easy. It's the same the same way you do it. It's almost the same way you do it in a legislative court. Anyway, constitutional courts are sufficient text if the General Assembly never exercised the power to establish inferior courts with that which it was clothed, and its exercise is a purely matter of legislative discretion, the whole element of sovereignty known as judicial power would exist, confined to tribunals which may be said to be of constitutional creation. So let's see what this means. Meaning, if the legislature chooses not to create inferior courts, the judicial power remains fully vested in the constitutional courts in Alabama, which are the Supreme Court, circuit courts. I'm not really sure about the probate court because this case was decided before the Constitution was amended again, because they amended the Constitution again. But I know for a fact that the Supreme Court in Alabama and the Circuit Court in Alabama are courts of general jurisdiction. The appellate courts in Alabama are not courts of general jurisdiction. They were created by the legislature. These courts, established directly by the Constitution via the sovereign people of Alabama, are sufficient to exercise the state's entire judicial authority, embodying the sovereignty of the judicial branch. So what this means right here is this court, this superior court, this court of general jurisdiction called the Supreme Court and the Circuit Court, they can exercise common law jurisdiction without the legislature, equity jurisdiction without the legislature, admiralty jurisdiction without the legislature, and maritime jurisdiction without the legislature, because the system in and of itself is complete. Implication: the constitutional courts are the bedrock of Alabama's judiciary, capable of handling all judicial functions, equitable remedies, common law disputes, etc., without reliance on legislative created courts. This is significant for your trust, which emphasizes common law and equity over statutory law. What are they? They must be talking about. They still talking about trust, but I still want y'all to understand this. Y'all need to understand this. So let's see. So in conclusion, in State Ex Rel. Winter versus Sayer, the Alabama Supreme Court declared that the state's judicial power is complete and self-sufficient, with all judicial power vested in constitutional courts independent of legislative action to create inferior courts. The passage, the system, is in itself and of itself complete, means that the judiciary's authority, including equitable and common law jurisdiction, is fully active from the courts, for the Constitution's adoptions, not contingent on future legislative acts. This ensures courts can resolve disputes like those involving a trust under common law and equity. Hopefully y'all are getting this stuff, man. Hopefully y'all are getting this stuff. They're playing games with you. They think you're stupid. They're playing a word game with you. So before this video ends, I'm gonna try to get off here in about maybe about 3 minutes. I want to go and read a state constitution. I want to show y'all this. So we're gonna let's go to Google. And which state constitution do I want to? Let's go to Tennessee. That was random. Okay, Tennessee Constitution 2023. I need to make sure that it hasn't been amended. So I want to try to get the latest version of the Constitution as possible. Tennessee State Constitution. Click here to see a digital of the 18th. Okay, so that's the old one. Let's see. That's let me see. I need to know when was the last time it was. Let me see. Tennessee Constitution 2020. Go 2024. Let's check this one out. This one might be it right here. So it's page 16. Not really sure which one, but it's on page 16. So in the Tennessee Constitution, I want to know which courts in Tennessee are courts of general jurisdiction, aka superior courts that are created by this Constitution via the sovereign people of Tennessee. So I'm going to go to the judicial article in the state constitution, which is impeachment, elections, right here. See this? Right here. All right. The judicial power of this state shall be vested in one Supreme Court. So the Supreme Court in Tennessee is a court of general jurisdiction. And in such circuit, chancery, and other inferior courts as the legislature shall from time to time. So that's a little vague right there. It's a little vague. What are they talking about? Corporation courts. Y'all see this right here? Corporation courts. Anyway, it says shall be vested in one Supreme Court and in such circuit, chancery. Sorry, I don't know what they mean by such circuit, but if they call, let me see. If they call it a circuit court in Tennessee, then it's probably a court of general jurisdiction. But I can tell you right now, off the top of my head, the Supreme Court in Tennessee is a court of general jurisdiction. Chancery. So they don't. This is another word for an equity court too, by the way, just to let y'all know, chancery. So they must be separating. So it must be a circuit court. The circuit court must be a common law court, maybe, and the chancery court obviously would be an equity court. Not really sure, but this is just how you would look it up. So let's go to another constitution. Let's go to Iowa. Go to Iowa. Show y'all how to do this stuff. It's so easy. Iowa Constitution. Let's see. I'm not sure. Trying to find an updated version because y'all know sometimes they change these things. Let's see if this is it. It's probably not it. Let's see if this is it. This might be it. Nope, that's not it either. Iowa Constitution. This might be it right here. 23 pages. Okay, so let's see. Legislative, so distribution of powers, legislative, number 3, executive, operations. Where's the judicial at? Did I pass it? Judicial Department would be Article 5. Right. Let's go back one more. Oh, okay. Let's go down. 5 right here. Judicial Department right here. So if you're in Iowa and you want to know which court is a court of general jurisdiction in Iowa, this is what you should do. You're going to read your state constitution. So it's Article 5. Looks like section is going to be either Section 1. So Article 5, Section 1 or Article 5. Well, no, it looks like Article 5, Section. It might be Section 6. It's going to be 1 and 6. We're going to see. The judicial power shall be vested in a Supreme Court, district courts, and such other courts inferior to the Supreme Court. Okay, so these and such other courts got to be legislative courts. So the district court in Iowa is a court of general jurisdiction and the Supreme Court. So let's go down here and see jurisdiction of district court. The district court shall have a court of law, common law, and shall be a court of law, which is court of common law and equity, which shall be distinct and separate jurisdictions, and have jurisdiction in civil and criminal matters arising in their respective districts in such manner as prescribed by law. By law means statute. That's what bylaw means. I want to explain that a little bit, but I don't want to make this video too long. So let's do one more, and then we'll call it quits. Let's try something up north. Let's do Illinois. Illinois. Man, that looks terrible. I gotta find something that looks better than that. I'm not sure how up to date this one is. That looks like it's updated 2025. They probably updated it again. Constitution 2024. This might be it. In 1970, adopted a special not ratified. No. Trying to find something up to date. Cook County. Let's try this out. All right. So right here, adopted at special election on blah, blah, blah. I think this would be an updated version right here. So we go to the Constitution. We go to the judicial article, which is Article 6. And right here, the judicial power is vested in a Supreme Court and appellate court and circuit courts. So that's still being a little vague though. But that might be might do it a little different. So let me see. Judicial districts, Supreme Court jurisdiction, appellate court jurisdiction, judicial circuit. I like this one a little better. I like this one better. So states shall be divided in judicial circuits consisting of one or more counties. The first judicial circuit shall blah blah blah, and shall be as provided by law. Circuits composed. So they're mixing this stuff. So it's going to be a little confusing for me. But they're mixing it up. It looks like it. But if you can't find it in your state constitution, just go and read cases. The cases should clearly tell you which court is a court of general jurisdiction. You want to use the terms when you're doing your research. For if you're in Illinois, you would say you ask a question like let's go to Google right quick. Which Illinois court is a court of general jurisdiction? You see, in Illinois, the circuit court is a court of general jurisdiction. It has original jurisdiction in all matters except those where the Supreme Court has original jurisdiction. The circuit court hears all civil and criminal cases serving blah, blah, blah. So the circuit court. In Illinois, they call them circuit courts. These are courts of general jurisdiction. These courts can hear cases at law, in equity, common law, admiralty, and maritime. This is how you find out this stuff. You need this. Y'all need to start paying attention. I'm going to do a video next to show y'all, not today, but I'm going to do another video to kind of explain to y'all what happens, even though I already did it, but what happens when these courts that were created by the constitutions start exercising jurisdiction under statutes, because something drastically happens when they do that. And y'all need to pay attention for it, because that's what they're doing to everybody. That's why it's confusing everybody, because they're acting under statutes and they're enforcing statutes. Anyway, hope this video helped y'all. Hope you enjoyed it. If you have any questions, post them below. The Supreme Litigant is out. Peace.